Unrealistic timeframes. If I handed you 3,000 pages of medical records and documents and photographs and so on and so forth, and I said, I want you to make a couple $100,000 decision about this by tomorrow, you'd look at me like I was crazy. You can't process 3,000 plus pages in that time frame. You can't do it. The law typically, in the context of motor vehicle accidents at least, prior to a suit being filed, gives an insurance company at least 30 days to respond to a demand. I'm of the opinion that if you send a voluminous demand with thousands of pages and an insurance company asks you for additional time, you should give it to them. When an opposing party or an insurer asks you for additional time, what they're telling you is, hey, we're actually looking at this stuff. Give us time to actually look through it. So many people just bang their hand on the table and say, hey, 30 days is 30 days. That's all you're going to get is your 30 days. Well, you're tying their hands at that point. What if they simply cannot get through the information in 30 days? At that point, they have no alternative but to reject your demand. Be reasonable with your time frames. If you send 100 pages, then 30 days should suffice. But when you're talking thousands of pages, give them additional time. Unrealistic expectations. I think this is a pet peeve of mine, and I don't want to rehash everything we talked about last time, but I'm of the opinion that people's expectations are driven by what they see and what they hear about other cases. Well, you've got these, I'm going to call them big TV firms, is what I'm going to call them. The ones, the biggest firms on the earth, or the biggest firms in Atlanta, so on and so forth. They're putting out advertisements to say, hey, we got Miss Smith $1 million. We got Miss Smith $500,000. We got Miss Smith $100 million, whatever it may be. But at the end of those, they tell you, well, every case is different and we can't guarantee you $1 million. Well, if that's the case, why are you telling me about it? If every case is different, what benefit is it to you to tell me that you got this $100 million or $1 million settlement if you're just going to in the same breath tell me, well, I can't do this for you necessarily? We all know what the reason is to set that expectation. It's to set the expectation that, hey, this is what I can get. But what they don't tell you is these large firms are processing thousands and thousands of cases. I cannot emphasize that enough. Thousands and thousands of cases. And they are picking out one, maybe two a year that they're going to actually tell you about. They're not going to tell you about the other 9,999 cases that were just ordinary or mediocre. They're going to tell you about the one. I'll be straight honest with you. You give me the right set of facts, I'll let my 14-year-old son settle that case. He's got no law degree, no experience. He'll get him $1 million too with the right set of facts. It doesn't impress me. Realistic expectations, what does that mean? Well, it gets to valuing your case based upon the merits of your actual case. And that takes somebody to sit down with you and explain to you how these cases are evaluated. So I'm going to give you just a quick rundown of how to evaluate a case. Now, this is just how I do it. There's no way to say a case is worth X number of dollars with 100% certainty. Nobody can do that. Insurance companies and attorneys, they have, computers with artificial intelligence that try to do that, but they can't do it. And there's a number of reasons they can't do it. But what are we looking for? You'd start off with the medical bills, because those are tangible. We can say, hey, Miss Smith has X number of dollars worth of medical bills. This is what she has. Assuming those are reasonable bills and reliable, we can use those bills as a starting point. The next thing we're going to look at is the length of time that Miss Smith treated. Miss Smith entered treatment on January 1st, and she treated until Christmas. The next year she treated approximately 12 months. That's something that we can say for certain, the time frame. Then we're going to look at the injury. Was this an injury that was debilitating, or was it an injury that just was aggravating? What I mean by that is Miss Smith able to go about her day, but she just has neck or back pain, or does her leg hurt? Or is this a situation where Miss Smith just couldn't do anything for an extended period of time? We take that and we assign that a value, and the value we assign it is dependent upon a lot of factors that I'll talk about. But anyways, we assign that value, and you can multiply it out over that course of time to get an understanding of what her pain and suffering might be worth. And there's going to be ranges, high, low, and mid-range. We'll multiply it out. And then you ask, okay, when she stopped treating, is she still going to have issues? Does she need further treatment? And if she's still going to have issues, we use that same multiplier out into the future. If she's still going to have medical expenses, we determine what those are going to be and add those in. If she has lost wages, we add those in as well. What the multiplier is really dependent upon a number of things. And we could come up with new things all day long, but I'm going to give you just the basic ones. The biggest one is the venue. Every county is not the same. That's how Georgia sets it up. You have to sue in the county of the defendant's residence. So, like for me, I work in Sumter and Dougherty County, but I live in Crisp County. So if someone wants to sue me personally, they have to do it in Crisp County, assuming they stay in state court. If I get in an accident in Atlanta and hurt somebody, they've still got to come to Crisp County to sue me. So what county the defendant resides in is of critical importance, because counties are made up differently. The people in those counties, painting with a very broad brush here because I understand everybody's not the same, but we classify these counties as conservative, liberal, moderate, and that's real quick rundown of it. In a conservative venue, your multiplier is going to be less because the idea is the people there have more conservative views when it comes to money. Therefore, they won't award as much. Moderate, you get what that is, and in a liberal county, the school of thought is they have a more liberal view of money. Therefore, they're going to award more. So that's how venue can play into it. And then the multiplier, of course, you got to talk about the actual injury itself. If it's if it's debilitating or just aggravating, those are two quick breakdowns of it. If it's just aggravating, it's going to be less than if it's debilitating. But you have to go through this process and look at all these things to get a realistic idea of what a case is worth. Now, equally important to determining what a case is worth is determining what recoverable money is there out there. So if the person who injured you is indigent, meaning that they could not pay a judgment if you were awarded a judgment, then you're going to be stuck with whatever insurance money there is. And there are tools to help us find what insurance money is out there. First, the person who injured you, their insurance, and then your own insurance. But there are multiple layers. I see very often that attorneys skip over additional layers of insurance that could have been beneficial to their client. In an ideal situation, what happens is the reasonable value of the case matches up perfectly with the amount of insurance that's available. That's a perfect world, which means it rarely happens. More often than not, you're stuck in one of two scenarios. Either you have a catastrophic case where somebody died, but there's only minimal coverage that'll never even come, not that money could compensate for it, but they'll never come close to compensating for it. Or you'll have an injury with a lesser value with an exceeding amount of coverage. Let's kind of talk about those scenarios real quick. So in the scenario where you have a catastrophic loss and minimal coverage, this is where I talk about people putting their hands in folks' pockets. If you come to me with a wrongful death case, just let's do something classic here. It's a pedestrian strike, okay? James Smith was walking down the road and Jill Jones hit him, plowed him, killed him, and Jill Jones is at fault. Well, Jill Jones has got $25,000 worth of liability coverage. That's it. Well, the person who's hit, their family goes to an attorney and says, "Attorney, what should we do?" Attorney says, "Well, sign this piece of paper." Attorney gets the case. He gets a death certificate and an accident report. That's all that person has to get. Sends a letter to the insurance company. The insurance company sends back a check for $25,000. So fast fireballs are coming off the sides of it. The lawyer did nothing in that scenario, nothing to earn their fee whatsoever. If that lawyer was truly helping their client, he would have told the family, "Hey, all you've got to do is get a death certificate and call this person and tell them you want your money." That's all he'd had to do, was tell that person that. Is it ethical to take a third for doing what that attorney did? That's really not up to me. That's up to the bar. I just know that if I were that family after the fact, I would be upset about it. So beware of that. On the flip side, you have too much coverage for the injury. In that scenario, the defense has all the leverage because they know on their worst day you're not going to eclipse their coverage. So how do you get around that? How do you do things to prompt a settlement at that point? Well, it really goes back to what we talked about earlier. You make sure you send a well-supported, thoughtful, and properly evaluated demand. You say you have to. You can't just say I want all of it, because if you say you want all of it, you're going to be fighting forever because you're not entitled to all of it, more than likely. You have to have a really well thought out demand that says, "Hey, we will accept this," and leave the rest of that coverage on the table, because you're going to end up fighting for years over that, and you're probably not going to get it. So a well thought out demand. I want to make one thing real clear. We are always willing to go to trial. If the client wants to go to trial, we're willing to go to trial, and we're going to do everything we can in our power to make sure that trial works out in the client's favor. So don't take all this as meaning, hey, they don't go to trial, they're not going to fight for me. That's not the case. But what I don't want to see a client do is spend a dollar chasing a dime. I don't want to see them do that. I want to be able to tell them, hey, reading the tea leaves, looking down the road, this is where you're headed. I want them to have good information so that they can make the best decision for themselves. I don't want to just put blinders on them and say, hey, we're going to trial no matter what. I want them to have every opportunity to resolve their case under terms they're happy with. I have a lady right now, super sweet lady. I don't know if anybody is from Plains, but I've not met one mean person from Plains yet. Someone may prove me wrong, but this is the sweetest lady I think I've ever met or had the pleasure of representing. She does not care. If I told her she was going to get $1,000 back, she would be just as happy as if I told her she was going to get a couple $100,000 back. She does not care. I am having to hold her kind of at a stiff arm in a polite way, letting her know, hey, you should not accept that. You should not accept that. We know what your case is worth. We're going to get there. And she said, I'm happy with whatever. I don't want clients just to be happy with whatever. I want clients to be happy with what they actually get. In an event a client tells me, hey, I'm not happy with this, well then we're going to go back to work and we're going to figure out a way to get them more. You know, this is all just information. This is information about things we can do short of a trial. This is information about things that people need to consider when they are potentially facing a trial a year or two later. But under no circumstances should this be a suggestion that we're going to shy away from trial at any point in time, because that's certainly not the case.